Bom dia, Marcela. Para confirmar, você será a primeira oradora da equipe 2501, correto?
Correto.
E depois sua colega Laura Rodrigues Gonçalves.
Isso.
Ok. Você terá 13 minutos, Laura 15 e 2 minutos para réplica.
Isso.
Perfeito, então. Mariana, eu vou, assim que chegar o primeiro juiz, eu vou para ele na sala do breakout para poder passar instruções. Você já está como co-host, então você pode admitir pessoas que pedirem para entrar, certo?
Tá bom. Aparece um negocinho aqui, né?
Isso,
Pedindo pra
isso.
entrar.
Pronto, aí você pode admitir. Se for juiz, você manda para a sala do breakout para poder passar explicações.
Tá
E aí
bom,
depois você
deixa.
passa as explicações gerais para as equipes que forem necessárias.
Tá bom, pode deixar. Tatiana Cardoso.
Isso, ela é juíza. Vou passar ela logo para a sala do breakout.
Olá, bom dia. Só para confirmar, Leonardo e Jade. Leonardo fica com 16 minutos de fala e Jade com 14 minutos de fala, certo?
Certo, certinho.
Então tá, tudo pronto. A gente só tá aguardando aqui começar.
Hello, everyone. Good morning to all competitors. My name is Rimelo. I will be, alongside Mariana Shurato, will be acting as bailiff for this round, so please turn on your cameras. You are already instructed with all the rules of the competition, and this court will now be in session. The case before the court is the case concerning questions relating to protection of pets and international trade measures. The parties are the applicant, the federal states of Alduca, versus the respondent, the Republic of Rumbeti. The applicant and the respondent are each allocated 30 minutes to present their pleadings. The federal states of Alduca may begin their presentation as President Sharmista allows, and she is accompanied by Judge Tatiana Cardozo Squef. These two judges will be serving this specific round. President Sharmista.
Yes, please begin your submission, beginning with applicant 1.
Good morning, Madam President, Your Excellencies, may it please the court. My name is Marcela Guerreiro Bruneto, and I have the honor to appear on behalf of the federal state of Alduca, the applicant in today's proceeding. I will speak for 30 minutes. My co-agent, Laura Rodrigues Gonçalves, will speak for 50 minutes. We would like to reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 30 minutes, I will be submitting that. First, Rumbeti violated some resolutions of CMS. Second, Alduca diplomatic note forwarded on January 2019 to Rumbeti was in accord with the resolution 7.5 of CMS. Third, Rumbeti's actions violated CBD. And fourth, Alduca's actions were taken accordingly with the bad conservation measures in a climate change context. My co-agent, Laura Rodrigues, will demonstrate that Rumbeti violated the duty to prevent transboundary harm. Second, Rumbeti's actions violated the provisions in Eurobats agreement. Third, Alduca complied with the Eurobats agreement. And fourth and last, Alduca did not violate international law in regard to trade measures for Tapegum products. Would Your Excellencies like a summary of the facts? Okay. So, Your Excellencies, our first argument is that Rumbeti violates the Convention on Migratory Species, CMS. The lack of regular monitoring of the wind farms by Rumbeti and of post-environmental impact studies do not fulfill CMS. CMS 7.5 resolution recognized a mistake: the lack of sustained research on environmental impacts and effects of the wind farms, and the lack of data on the distribution and migrations of species concerned. Furthermore, it is concerned about countries regularly monitoring the wind turbines plants. Rumbeti only made the study, EIA, during the project and at the beginning of the works, and yet Rumbeti never released those studies. Furthermore, during the construction of the wind...
Agent, just one question. Is there an obligation to release the EIA?
Yes, it is an obligation to release the EIA in situations like this when a project may be harmful for another country. So, Rumbeti,
where is this obligation found? Where is this obligation found?
Your Excellency, we can find this, for example, in the pupils case, in which the two countries, Uruguay and Argentina, both members of Mercosur, there was being a construction of 2 pupils in the border, and Uruguay was obligated to inform Argentina about the project.
But hasn't that obligation, agent, derived from the Uruguay River Treaty instead of being an obligation of international law in that case?
Francie, can you repeat the question, please?
Hasn't that obligation in the pulp mills case derived from the Uruguay River Treaty instead of general international law?
No, this case was to International Court of Justice, and in that the judge recognized that the duty to inform is a general obligation. So Romedi only made the study IA during the project and the beginning of the works, and we had never released those studied. Furthermore, during the construction of wind farms, Romedi stopped monitoring. According to the Professor Thomas Fisher, the whole project requires a multi-phase study. The EIA must be done in all phases, and Romedi has not done that. In this way, there is a violation of Romedi's comment in the international agreement. On the other hand, Alducra diplomatic note forwarded on January 2019 to Romedi was in accord with the same CMS resolution, the 7.5. By urging the concerns regarding installation of the government subsidized wind farm on its neighboring country and its effect over migrant bat population, Alducra acted accordingly with the CMS resolution. The resolution calls upon parties to identify areas where migratory species are vulnerable to wind turbines and where wind turbines should be evaluated to protect migratory species. For example, Your Excellencies, according to the Eurobats publication 6, when wind turbines are proposing areas of high bat activity or close to routes, they should be resited away from these areas. So Alducra acted right.
Wasn't the respondent acting in furtherance of its obligations under another treaty? So how do you reconcile both obligations under international law?
Your Excellency, can you please repeat your question?
You said that the act of construction of the wind turbines is in violation of its obligations under CMS resolution, right? So wasn't the respondent acting in furtherance of its obligations under another treaty? So how do you reconcile both these obligations?
So Romedi should have inform, and they should see the scenario when wind turbines are proposing areas of high bat activity and should be recited. Romedi also violated, how I said, CBD, CMS, Eurobats, and right now in this scenario, we don't see any specific agreement that had followed until now. So Alducra acted right when he sent a diplomatic note explicit that there was indeed a negative impact on the Royal Nocturne population and to ask for the current suspension of the construction in that place, a bad migratory location. Your answer is not enough. Romedi also violated CMS resolution 11.27 by agreeing to the construction of the wind turbines on a migration road of species listed in Appendix 2 of this convention. According to the USGS Science for Change Road, bats are being found dead close to wind turbines all over the world. Bat fatalities now have been documented at the most wind fatalities in US and Canada, and estimated that tens to hundreds of thousands bats die at wind turbines in North America each year.
Asian, did any bat die in your territory, or was it only the respondent's territory?
There is no bats are not found. There is no specific location because the wind turbines, the wind farm is in the border between the two. So I don't have exactly this information, but the NGO Chitopé Cruzeiro found bats that will die in that location that is in the border between these two countries. So the 2014 CMS guideline, renewable energy technology and migratory species guideline for sustainable development reinforces the need of pulling the wind turbines away from any rare species, habitats, or a migration road as an effective way to avoid the adverse effects of the wind turbines, the wind energy facilities on migratory species. Nevertheless, Romedi's attempt to implement a sustainable source of energy agreed on the construction of the wind energy project on the Royal Nocturne Migration Road, a fact that according to the record, page 10, paragraph 17, the government was already aware of. Your Excellencies, above and beyond, Romedi had other options of sustainable development, and yet it chose the one that would directly affect the species mentioned and its migration road. In this context, yes.
Excuse me. What would be the other options then? You just mentioned that there would be other options. So what would they be?
solar energy, tidal energy, geothermal energy, biomass energy, and even though wind energy, but not in that place, a bad migration road. So in this context, the Bat Conservation Group, Chitopac Crusader, urged Rombetti and PECO to implement mitigation measures for the construction and operations of the turbines, which they constantly deny to do. On that account, Rombetti did not attempt to use responsibility to preserve a species protected under international law. On the contrary, consolidated his wind energy project in such a way that the result could not be other than the constitutional race of the royal nocturnal mortality. Getting to another point, an extremely important topic is about CBD. Your Excellency Rombetti breached the state's duty to inform ADUCRA about the wind farm project and its construction environmental impacts. CBD Article 14 established that parties should promote the exchange of information concerning activities under their jurisdiction, which are likely to significantly affect the biological diversity of other states. So by not notifying ADUCRA about the construction of the wind energy beforehand, nor sharing the information collected in its EIA with the neighboring country, having the knowledge that the area designated to the construction of the project is a bad migration road, and that these animals are of great importance to both countries, it is possible to say that Rombetti violated CBD. Granted, getting to our last point. By opposing of the construction of the wind farm complex in its neighboring country, ADUCRA is granting that appropriate measures shall be taken away to conciliate climate change situation alongside efforts to preserve bat population. In Eurobat on the 7th and 8th session meeting of the parties, it stated that it is of utmost importance to prevent that climate change keeps worsening, but that current action shall be taken away that animal population, bat included, could not be harmed in the process. In its preludes, Kyoto Protocol covers and stimulates the construction of wind energy as one of the many measures to reduce CO2 emissions in the atmosphere. However, resolution notes that there is in fact a scientific evidence that wind turbines can prove to be fatal to both Brazilian and migratory bat species. So taking that into account.
Do you have concrete evidence, Agent, do you have concrete evidence that the construction in fact caused the deaths of the bats? Apart from anecdotal evidence.
I'm sorry, Your Excellency, we don't have exactly the data that these bats are being killed by the wind turbines, but why that? Because the government of Rombetti didn't allow the NGO do that work, and that's why we don't have this data. But we have so many facts that we can say that there is a causal link that make us possible to say that yes, those bats are being dying because of the wind turbines. We know the fact that wind turbines kills bats, according to Eurobats, according to the US CS, Science for a Changing Road. We also have the fact that that location of the wind turbines are a migration road of bats, and this is in the record. And also the fact that NGO found many bats dead in that area. So here we have a kind of causal link to make us possible to say that yes, the wind turbines are killing those bats. Ranks, you finished? Do you have any more questions? So may it please the court, if ranks have no further data, my assistant, I thank the court for his time and indulgence. It was an honor. Now I will pass the floor for my co-agent, Laura Rodriguez.
May I proceed, Your Excellencies?
Please go ahead.
Thank you. Good morning, Madam President, Your Excellency. My name is Laura Rodriguez Gonzalez, and I appeal on behalf of the Federal States of ADUCRA, the applicant in this case. I'll be addressing my speech for 15 minutes, as my co-agent said, regarding the following issues that, first, Rombetti violated the duty to prevent transboundary harm. Second, Rombetti's actions violated provisions from the Eurobats agreement. Third, Alducra complied with the Eurobats agreement. And our fourth and last point will be that Alducra did not violate international law in regard to its trade measures for tapagium products. So may it please the court, my first point would be that Rumberi violated the duty to prevent transboundary harm, in that by allowing the construction of the wind farm, Rumberi violated its duty to prevent transboundary harm. Transboundary harm happens when one country's actions result in harm to another country or party that lies beyond the jurisdiction of the country which caused the harm in the first place. The damage in the present case is that the operation of the wind farm in this particular area, a known part of bats' migration routes in the continent, is causing a high rate of bat mortality. Not only does this affect all neighboring countries, for it is a direct danger to biodiversity in the area, but it could also financially affect Alducra's agave farmers, which are legally required to use only bat-safe farming practices. Hence, if there's a spike on bat mortality due to the wind farm in a known migration route area, it is likely that fewer bats migrate to Alducra and pollinate its agave farms. We must also consider that there are 4 elements which characterize the notion of transboundary harm, and all of them are present in this case. The first element is that of a physical relationship between activity and damage. And despite the limited data on the rates of bat mortality, considering also Rumberi's restriction in monitoring of the wind farm area, it's safe to say that the operation of the wind farm is effectively harming the bats and causing the spike on bat mortality. For we have monitoring of the area up until Rumberi and PECO forbade it. And there's also ample knowledge and studies which point to the fact that operation of wind turbines is harmful to bats and avifauna in general. For example, an intersessional group from Eurobats in 2014 published the Guidelines for Considerations of Bats in Wind Farm Projects, which in the least shows us that wind farms are a real and recognizable threat to bats. The second element which characterizes transboundary harm is that of human causation, and this element aims to exclude natural disasters from being considered transboundary harm. And it's also present in the case, for the harm has its origin in a man-made wind farm put into operation. The third requirement is that of a certain threshold of severity that requires legal action. And it's safe to say, just by the fact that this case made its way into international courts, that the damage was sufficient to provoke legal action. Finally, the last requirement.
Excuse me,
yes.
You just mentioned the third element as being severity, and you just said that by bringing it to an international court, that would be severe enough. Do you have any other evidence that would sustain your argument in regard to severity?
Your Excellency, we believe that this argument that it made its way into international courts is already very relevant, because when you read about transboundary harm, the point people use to make this argument is that it is enough, the severity is enough to provoke legal action. And since this case made its way into international courts, it is clear that legal action was ensued. Also, again, in the last requirement is that of a transboundary movement of the harmful effects. And as said by my co-agent, the wind farm is close in the border between Alducra and Rumberi, which also happens to be part of a migration route. And due to its location, many bats are being killed. And as a direct consequence, Alducra's environment and population will suffer. It is therefore clear.
I don't understand how it will be transboundary harm if the bats died in the respondent's territory, and there is no, to use the words that your co-agent used, there is no direct causal link that I see between the construction of the wind farm and the bats. So could you elucidate on both these points?
Yes, I understand your point, Your Excellency. Thank you. We have that even though the bats are being found in the respondent's territory, for as far as we know, this territory is close to the border between both countries, and it is part of a migration route. And not only does this affect Alducra's biodiversity, for it is likely that fewer bats will migrate to Alducra, hence being there a transboundary harm, but also there will be financial harm arising from this fact, in that Alducra's farmers are legally required to use only bat-safe practices. And with fewer bats migrating, it is likely that their crops will suffer from this, since they are not allowed to use any other sort of farming methods that are not bat-safe. My next point, Your Honors, is that Rumberi violated the Eurobats agreement. Also, by allowing construction and operation of the wind farm, Rumberi violated provisions from the Eurobats. Paragraphs 3 to 7 of Article 3 establish obligations to the parties of the agreement, and among them is the obligation to conserve bat habitats and the naming of an appropriate body which is responsible to provide advice on bat conservation and management. During the construction of the first phase of Rumberi's wind farm, the government in PECO declined Quirub-Terra's Crusaders' proposal to implement mitigation measures for the construction of the wind turbines and supporting infrastructure. After that, even though Quirub-Terra's Crusaders surveys showed the negative impacts caused on bats during the first 2 years of operation, Rumberi did nothing about it. No mitigation measures were implemented. In addition to that, yes.
Why should we take into consideration the document made by the Crusaders at this point by this court?
We should take it into consideration because it is the closest thing we have to data of the numbers of bat mortality in the area. It is, in fact, the only data we have of the number of bat mortality in the area. And since we also rely on studies and on other cases that wind turbines have harmed bats in other areas, it is important that we take this number into account. And it would be important to resume monitoring to see if further damage is being made.
Agent has this. Sorry, please go on.
I would just add if this court has ever addressed reports made by institutions such as the Crusaders before within its decisions for its legal reasoning to support.
Your Honor, I'm sorry, I don't have that information. Rumberi also violated Resolution 8.4 of the Eurobats Agreement by ignoring the negative impacts on bats caused by the wind farm operation. A guideline to the implementation of the Eurobats Agreement published in 2019 by Anthony Hudson, Ferdia Marnell, and Ruth Bederman say that Resolution 8.4, and I quote, encourages a range of measures to minimize the impact of wind farms on bat populations, including the use of blade feathering and cutting speeds to reduce mortality, excluding wind farms from areas with a special focus on bat protection, full evaluation of the potential impacts of bats on all wind energy projects, and with the survey and monitoring of data being made available. As pointed before, Rumberi declined to implement mitigation measures, both when Quirub-Terra's Crusaders suggested it during construction and again when Alduca suggested it through a diplomatic note. Not only that, they stopped the NGO from monitoring the area, thus failing to comply with Resolution 8.4. My next point.
What's the value of this resolution?
I'm sorry, could you repeat, please?
What is the value of this resolution in international law?
Resolutions aren't binding. They represent an opinion that lawmakers or government bodies want to emphasize. Nevertheless, resolutions are always made within the scope of an agreement or a convention. So they overall embody the same commitments and values as the convention or agreement in which they're part of. So it only makes sense for people, for parties who comply with the agreement or convention to comply with the resolutions, since they embody the same values and commitments. My next point, Your Honors, will be that Alduca complied with the Eurobats Agreement. And Alduca complied with the Eurobats Agreement in regards to bats in agricultural landscapes and bat protection. Pertaining to the first matter, Article 4, Topic 1 of the agreement permits the parties to take whatever legislative and administrative measures necessary in order to give effect to commitments made in the agreement, stated mainly in Article 3. Among these commitments is the duty to protect known bat feeding and shelter areas, as well as the duty to promote bat conservation and public awareness of the importance of bat preservation. With this in mind, Alduca passed domestic legislation in 2015, which became effective in 2019, requiring all agave farmers in the country to use bat-safe farming practices, since the Archetype and long-nosed bats and other bat species traditionally feed on and pollinate agave farms in Alduca. Thus, since the statute passed also include labeling products bat-safe or not bat-safe, it also acts as a means of awakening public awareness to bat conservation. Pertaining to the second matter of bat protection, Topic 6 of the aforementioned article states that each party shall take additional action as it considers necessary in order to safeguard bat population it identifies as being subject to threat. Once Quirub-Terra's Crusaders surveys on bat mortality in Rumberi's wind farm came to Alduca's attention, as well as the fact that the wind farm is built in a known migration route, Alduca took action in writing a diplomatic note formally requesting Rumberi to shut down the wind farm and implement mitigation measures before resuming operation, as we have established that wind farms are a recognizable threat to bats. My last point, Your Honors, is that Alduca did not violate international law in regard to its trade measures for tapagium products. Alduca's actions in regard to trade and taxation measures are in accordance with international law, particularly with the ARTA and the CBD. In 2019, the country passed a statute which stipulated that in tapagium made without bad safe practices, there shall be a 20% tax. Firstly, we must point out that Alduca's intention with said statute wasn't to create a protectionist tax, but to encourage the adoption of bad safe practices at an international level. If a foreign country wishes to sell tapagium products in Alduca, and these products were made with bad safe practices, no additional tax will be applicable, meaning that the statute isn't protectionist. Secondly, Article 10 of the ARTA offers a list of exceptions as to when a country party to the agreement may apply taxes, and one of these exceptions pertains to the necessity to protect animal life. By establishing taxation to products which formed agave used in the making of tapagium without bad safe practices, Alduca created a trade measures to protect and preserve bats, which is perfectly allowed by the ARTA.
Agent,
Yes.
Wouldn't that rule under Article 10 be only applicable as or as a discrimination matter? I mean, aren't you, by applying that rule, being discriminatory when it comes to products regarding other states?
Your Honor, I understand your point. However, the biggest intention beyond this statute was to encourage bad safe farming practices, the adoption of bad safe farming practices at an international level, which is allowed by the exception under the ARTA since it protects animal life, and also by Article 11 of the CBD. Said article states that each contracting party shall, as far as possible, adopt economically and socially sound measures that act as incentives for conservation and sustainable use of components of biological diversity.
But still, Chapter 10, Agent, says that such measures are not to be applied in a manner which would constitute a means of arbitrary or unjustified discrimination between countries. Aren't you being discriminatory in that sense?
Your Excellency, Alduca is not being discriminatory, for the intent behind it all is to encourage bad safe practices at an international level. And once we consider the ARTA and the CBD, which the CBD also encourages the adoption of economic measures to act as something to incentive conservation and a sustainable use of components of biological diversity, Alduca has acted in accordance to international law, and it isn't a discriminatory measure. For example, in 1993, the American Secretary of Commerce certified that Norway may be subject to US trade sanctions for its resumption of commercial hunting of minke whales, an activity that was already under moratorium under the International Whaling Commission in 1982. So those trade sanctions from USA in 1993 had the purpose of assisting the protection of minke whales, similar to Alduca's approach in the present case, in which the taxation aims to protect the bat population. The objective of taxing tapagium produced with non-bat safe practices is, as I said, to encourage countries to adopt bat safe farming, consequently protecting the environment, bats, and biodiversity. In that way, the measures taken by the state are fully complicit with international law. Do your Excellencies have any further questions? If your Excellencies have no further need of my assistance, I thank the court for its time and indulgence. It was an honor.
May I proceed? Good morning, Madam President, Your Excellencies, agents for the applicant. May it please the court. My name is Leonardo de Boro Diniz Gonçalves, and with my co-agent, Ms. Jade Leal, I have the honor of appearing on behalf of the Republic of Fromberi, the respondent in the present case. In today's proceedings, I'll be discussing for 60 minutes why Fromberi did not violate international law with respect to its wind farm project, and my co-agent will then discuss for 14 minutes why Alduca violated international law with respect to its trade measures for tapagium products. If Your Excellencies have no preliminary observations, would you like a brief statement of the facts? Your Excellencies, our arguments will be displayed on two main topics. Firstly, Rombetti prevented the occurrence of harm, and secondly, Rombetti's wind farm project avoided climate change issues. To begin with, Rombetti prevented the occurrence of harm by conforming to the duty to prevent transboundary harm. This duty is enshrined in Convention on Biological Diversity's Article 14D and in Article 3 of the ILC Draft Articles on Prevention of Transboundary Harm, which advocates that states of origin shall take all appropriate measures to prevent significant transboundary harm or at any event to minimize the risk thereof. Furthermore, in the Pup Mills case, the ICJ recognized the duty to prevent as a custom of international law, stating that this duty is derived from the due diligence obligation, which comprises the mitigation and monitoring of impacts that might occur, as well as the conduction of an EIA, Environmental Impact Assessment.
Agent, what is customary international law?
Your Excellency, customary international law comprises a state practice, meaning the reiterated practice of states, and also opinion juris, meaning the recognition of this law, this custom, this practice as a custom of international law. And it is clear that Rombetti acted in conformity with the due diligence duty to prevent transboundary harm, having conducted an EIA before the wind farm construction began. Having conformed to the prevention duty, it should further be noticed that Rombetti did not cause any transboundary harm on other countries. Once that the standards which define transboundary harm require that conducts from the implementing country must have physical connection with the harmful results in issue. In this sense, the ICJ ruled in the Costa Rica versus Nicaragua case that there must be a sufficiently direct and certain causal nexus between the act of a state and the injury suffered by other nations.
But agent, the applicant was stating that you did not take any steps in order to mitigate the bat mortality. Can you address that issue by any chance?
Indeed, Your Excellency. Rombetti did not take any mitigation measures because such a duty should be taken in cooperation by both parties, considering that mitigation measures are an expense for the respondent, which is a developing nation, and as the Paris Agreement and the United Nations Framework Convention on Climate Change assert, the developed nations should be the ones to take the lead and to financially assist and transfer technology to developing nations in order to help them in ways in such to cost the mitigation measures.
So does that exempt you from fulfilling your obligations altogether, just because you're a developing nation?
Indeed not, Madam President. The respondent in the present case has other concerns, such as the mitigation of climate change. And one matter is not mutually exclusive. Both matters are not mutually exclusive. The mitigation measures to safeguard population of bats and the mitigation of climate change are not mutually exclusive. And because the mitigation measures for the climate change also helps to mitigate and to avoid bat fatalities, because the climate change indeed has detrimental effects on bats, such as the differentiation on stink in both blooming and migration cycles, therefore threatening the life and threatening both pollinators and plants. All things considered, it remains evident that there is no causal connection between the wind farm constructed by Rombetti and the death of the royal noctule bats, and therefore the respondent complied with its duty not to cause transboundary harm. That is to say, Your Excellencies, given that Alducra itself has claimed not to know how the construction process may have impacted bats in paragraph 22 from the record, it is unreasonable and dissembling to affirm that the wind farm has caused the bat fatalities only because such bats were found dead near the wind turbines.
Agent, are you aware of the precautionary principle?
Yes, Your Excellency.
So even if you did not have enough scientific evidence, you did have the report of that NGO, right, which said that this would be detrimental to the bats. So why did you not implement the precautionary principle then?
I understand your point, Madam President, but the precautionary principle is non-binding according to once that it's not enshrined in any convention or in any or in customary international law.
Hasn't this court ever applied the precautionary principle?
Your Excellency, this court has applied the precautionary principle, mainly in the Gavitikovo and Aguimarães case, but as a custom of a general practice of law, this court has never applied the precautionary principle as a custom. The only evidence is the dissenting opinion from Judge Cansado Trindade, but as we can assert, this wasn't the decision that the court has taken as a whole.
Hasn't this court said that the precautionary principle is a principle found in general international law? So is that the same as customary international law?
No, Your Excellencies. I don't think you. I mean, the precautionary principle is not a general obligation. It is not a custom. It's not binding, and the court has never recognized such a principle as a custom, as a general obligation of international law. Only to a specific case, namely the Gavitikovo and Aguimarães, but the court has never addressed such a principle, the precautionary principle, as a custom or as a general obligation for erga omnes, for every state to comply with. Furthermore, there is no scientific basis, technical data, or eyewitnesses that can corroborate with Alducra's thesis that the royal nocturnal bats were killed by the wind turbines. Alducra's mere assumptions do not suffice for the liability of Rumberi's activities to the damage occurred. Moreover, Your Excellencies, transboundary harm is absent in the present case. Once that, according to Article 2, Paragraph 4 of the ILC Draft Articles on Prevention, the harm must lead to a real detrimental effects on the environment, and it must be more than detectable. In addition, such detrimental effects must be susceptible of being measured by factual and objective standards. It should be noted that the royal nocturnal bat population number is unknown, and that there is no record regarding the quantity of bats that used to die in the wind farm area before the construction of such a project.
Isn't it true that the bats that are dying in a higher number every year?
Yes, Your Excellencies, it could be so, but there is no causal link between the wind turbines and the death of such bats, and therefore there's no possible way to accurately measure the occurrence of royal nocturnal bats' deaths so that it can be regarded as a harm. Rumberi prevented the occurrence of harm by conforming to the precautionary principle, as I previously mentioned. Your Excellencies, the second subject of our arguments is that Rumberi's wind farm project avoided climate change issues by conforming to the Convention on Biological Diversity. Rumberi complied with CBD as for the wind farm is a manner of preventing climate change impacts on biodiversity, fostering the conservation thereof. As I previously mentioned, the climate change causes differentiation of sink in migrations and blooming cycles, thus threatening both pollinators and plants. Other critical impacts of climate change on bats can be found in the rapid alterations in the species distributions and interactions, causing changes in the range of the migratory species. Moreover, reduced water availability in arid environments and the spread of disease are among the detrimental consequences of climate change on bats. In conclusion, if such changes from the climate change are affecting bats, which have an excellent mobility, the impacts on other animals that are less able to escape unfavorable conditions may be even more dramatic, according to the International Scientific Journal of the Mammal Society.
Asian, but is there not a specific resolution that tells you explicitly to not construct these wind farms that would be detrimental to the bat?
Indeed, Your Excellency, the resolution from Eurobats 8.4 and 8.11 and resolutions from CMS 11.27. But
So how do you reconcile these resolutions, the obligations under these resolutions and the UNFCCC?
We submit, Madam President, that resolutions are non-binding instruments of according to international law. Additionally, the harmful effects of climate change also tackles the overall biodiversity, once that bats play important ecological roles as top predators and pollinators. Hence, there may be an increase in insect pest abundance and a reduction in pollination of plants. Your Excellencies, Rumberis Wind Farm project avoided climate change by respecting the Sustainable Development Principle. CBD's Article 20, Paragraph 4 recognizes that economic and social development and poverty eradication are the first priorities of developing countries, and it is certain the poverty alleviation promoted by Rumberis Wind Farm, considering that the wind energy sector is a potential employment generator. To exemplificate, there are more than 100,000 workers in the wind energy sector in the United States. In addition, the Vienna Declaration and Program of Actions in paragraph 11 observes the right to sustainable development, meaning the equity on developmental and environmental needs of present and future generations. All things considered, Rumberis Wind Farm project is supported by the right of sustainable development. Once that these environmental measures aims to stimulate a healthy economy in a developing country, while combating climate change and ensuring the basic human needs from both present and future generations. That is to say, Your Excellencies, the wind farm has a continued usage, being able to be enjoyed by generations to come. Also, this energy source is a cost-effective one, and thus it is capable of submitting to the Sustainable Development Goals 2030 agenda, which asserts that providing affordable, reliable, sustainable, and modern energy for all is the seventh goal from this agenda.
Agent, I asked the agent from the applicant which would be other measures to be taken as solar energy and other sorts of energy. Why couldn't you choose any other source of energy, and you chose the wind formulation in order to fulfill your duties under this sustainable development, under the 2030 agenda, and so on?
Your Excellency, wind farm energy, wind energy as a whole has its benefits, and it is the most cost-effective energy source above all. And also, we can state that every energy source have its side effects. But nevertheless, the mitigation measures, as I previously said, should be taken in a cooperation sense by both the respondent and the applicant. But the applicant, instead of addressing mitigation measures and helping and assisting the respondent in the present case, Alducra, on the other hand, Alducra imposed burdens on the respondent, asking for the wind farm to be shut down and asking for the respondent to take mitigation measures all by itself. When we all know that the respondent is a developing country. In conformity to the general principle of equity, the common but differentiated responsibility principle advocated in the UNFCCC Principle 1 states that the parties have the common responsibility to protect the environment, in this case, the climate system, although they have different obligations to prevent harm based on their factual circumstances, such as social and economic condition. In this sense, the UNFCCC asserts that the developed countries should take the lead in combating climate change according to their greater wealth and their share of contribution in most of the global environmental problems. Paradoxically, in accordance with UNFCCC, by demanding the wind farm to be shut down, as I previously said, Alducra imposed burdens on Rumberi. In other words, the renewable, may I finish my pleadings, Madam President? To sum up.
Just wrap up your arguments in the next 30 seconds, please.
Okay. Your Excellency, to sum up, we would like you to adjudge and declare that Rumberi did not violate international law with respect to its wind farm project. Thank you. It has been an honor arguing before this court.
May I approach the bench? Well, good morning, Madam President, Your Excellencies. My name is Adila Al, and I will be using the next 14 minutes to defend the Alducra violated international law with respect to its trade measures for tapaceous products. May it please the court. Well, to begin with, Your Excellencies, I will present that Alducra's trade measures do not conform to the exceptions of paragraph B and G of Article 10 of ARTA. Alducra's trade measures require in its 2019 statute that agave farmers allow 5% of agave flowers to crops to flower as an alleged way to accomplish the interest of conserving the beds. Accordingly, in paragraph B of Article 10 of ARTA, there is an exception that safeguards trade measures when they are B, necessary to protect human, animal, or plant life or health. And now I repeat, necessary to protect human, animal, or plant life or health. This exception is validated only if there is a close link between the measure and the objective advocated in paragraph B. Nevertheless, this necessity condition is not present in Alducra's protectionist regulation, which was necessary to protect animals. When Alducra imposed the aforementioned agricultural policy, the state did so with no support in scientific data or any research in the matter. And this practice, which was adopted in advance of Alducra territory, has no evidence of protecting the environment of the beds. Thus, Alducra failed to comply with the exception in paragraph B. Moreover, paragraph G of Article 10 of ARTA is an exception that allows trade measures by states that aim to conserve accessible natural resources. However, this exception must comprise a notion of sufficient nexus between the trade measure and the scope of conserving accessible natural resources. This sufficient nexus is absent in Alducra's measures because the statute's requirement of imposing unreasonable farming practice does not have any scientific base to be considered a conduct that could conserve the beds. In the shrimp turtle case, the World Trade Organization appellate body decided that the state's measures cannot be disproportionately wide in the scope and reach in relation to the policy objective of protection and conservation. In other words,
what is the value of the case you just cited, agent?
Well, Your Excellency, the shrimp turtle case has a report from the appellate body of the World Trade Organization, which is present in ARTA, saying that the World Trade Organization appellate body shall be a subsidiary source in Article 15.
Okay. And how does this court recognize a subsidiary source? What is the basis of recognizing the subsidiary source for this court?
Well, since both nations are parties in ARTA, this court shall understand that what is being stated on the convention shall be a rule. So, since ARTA is saying that the appellate body shall be a subsidiary source, this court shall see it as it is. In other words, as I was saying, the means adopted by states have to be reasonably related to the ends of conserving animals, which Alducra failed to. Your Excellencies, also, Alducra's trade measures violate the chapeau of Article 10 of ARTA. The chapeau prohibits the trade measures to discriminate arbitrarily or without justification. Alducra's trade measures, however, discriminate in both these manners. The World Trade Organization appellate body in the shrimp turtle case asserted that
excuse me, before you move on to that case at hand, the applicant, when I asked about Article 10, said that their measures were not discriminatory. Can you address that issue on how you were saying that the measures are discriminatory, different from what the applicant has stated, please?
Perfectly, Your Excellency. Well, the statute was approved in the applicant's territory in 2015. When the applicant is saying that the respondent shall adopt the statute in 2019, it is considering that the nation has already 4 years to adopt this statute and 6 years, I'm sorry, and to be ready to attach these matters. So the respondent clearly has a disadvantage since it needs to be prepared to adopt the issues that the statute is imposing. So in this case, there's a discrimination and there is a disadvantage.
Agent, so are you saying that this violates the national treatment principle, which then, can you tell me, if it does violate the national treatment principle, can you tell me whether or how the products are like products here?
I'm sorry, Your Excellency, can you please repeat your question?
Sure. So, firstly, are you arguing whether the applicant's actions violate the national treatment principle? If yes, can you tell me how the two products, how the domestic products of the applicant and your products are like products? And what are like products?
Well, Your Excellency, the product in the end is the same. The whole difference is the process to grant it. So the respondent has a different process to find this product in the end. So, but in the end, the product is still the same.
Can you tell me the judicial determination of what constitutes as a like product?
I'm sorry, Your Excellency, but I will not be able to answer your question.
Okay.
The World Trade Organization appellate body in the Shrimp Turtle case asserted that there should be an analysis of the chapeau based on the principle of balancing of rights. The principle discerns between the right of a state to invoke the acceptance in Article 20 of GATT and the substantive rights of the other states. Thus, if a member exercises its treaty right in an abusive manner, which Al-Ducra did, negating the conflicting substantive rights of other members, that will result in a breach of the GATT and ARCA consequently. Al-Ducra's restriction of the Asian produce, cutting a gap, violated the principle of balancing of rights due to the standards derived from this principle, namely the 1, causal connection between the measures and the objective, and 2, the application of the least restrictions, and 3, the proportionality is strict to sensus. The lack of causal connection of Al-Ducra's measures with the scope advocated in paragraphs B and G of Article 10 of ARTA demonstrates that the applicant is not able to fit in the exceptions therefrom, nor in the chapeau of the article. Moreover, despite the Al-Ducra has applied trade measures such as taxation and labor, which increase the barriers of Rumbetti, there was less restrictive conduct that could be handled in a sense of cooperation, such as the sharing of funds and resources, the greater effort to negotiate domestic laws enacted by Rumbetti, aiming to Rumbettian producers, the negotiation of ARTA with the parties, and finally, educational programs to raise the awareness among Rumbetti's nationals. This, of course, derives from the context of multilateral trade agreement already in place between the parties, but which was not exercised by Al-Ducra. Although the appellate body in the Shrimp Turtle case has not specifically mentioned the word proportionality to analyze the chapeau, it indeed referred to terms such as good faith, abuse of rights, and reasonableness to express that must not be an arbitrary discrimination or a disguised restriction on trade between states. Nevertheless, the disadvantage caused by Al-Ducra's measure were disproportionate to the advantage aimed by it. The applicant neglected the economic injury the trade restriction imposes on Rumbetti as the only exporting country of the patients besides Al-Ducra. The measure impairs Rumbetti's competitiveness and its developing economy by not providing proportional terms for the transitional period. The 2019 statute was directed at Rumbetti and Al-Ducra, the only producers of papazian in the whole world. However, Rumbetti had never imposed any agave farming practice in its country before, while Al-Ducra was already familiar with the same requirements as applied since 2015, as I previously said. That is to say, Your Excellencies, that despite the 2015 studies in Alducra is not mandatory, the fact that Alducran producers were adapted so far in advance to the bad safe practice with 4 years of experience demonstrates that the applicant had much more time to adjust to the 2019 study in order not to be taxed. Since the trade restrictions are an unjustifiable discrimination in light of Article 10 of ARTA, Alducra contravene other series of norms in international law. Alducra's trade measures violated the national treatment obligation from the Article 8 of ARTA by acting in a discriminatory manner. The Article 8 prohibits unequal treatment between foreign imported and domestically produced products. Your Excellencies, there is no possible way in which Alducra can be taxed for its production methods of taxation, once that the farming practices in Alducra have already been bat-friendly since 2015. And that is why the applicant cannot conform to the taxable event in issue. Furthermore, there are several benefits guaranteed to Alducra derived from its protectionist trade measures, namely the enforcement of labels that makes Alducra taxation cheaper, granting favorable competitive conditions. This fair cost of the products lead to an advantage in the applicant's sales and production to the detriment of the taxation imported from Romania, thus violating the national treatment obligation. Alducra's trade measures violate the state sovereignty and non-intervention principle. As stated by Getz, Penal in the Tonadov case, one country cannot take trade actions for the purpose of attempting to enforce its own domestic law in another country, even to protect animal health or exhaustible natural resources. The state sovereignty principle advocates the equality of states and the self-determination right, which permits a country to set down its own political, economic, and foreign policies. In this sense, Alducra acted with an unlawful intervention of Romania's jurisdiction, tarnishing the respondent's sovereignty. Thus, the non-intervention principle is also violated in the present case, as Alducra forced its own policies on Romania, making the latter to adopt the applicant's extraterritorial domestic measures. Also, the general most favored nation treatment asserts that the trade measures applied by the regulating country on the most favored nation must be the same to all other states under the scope of state sovereignty and the principle of equity. Nevertheless, the advantageous measures conceded to Alducra as the most favored nation were not granted to Romania, since the developing country was the only one that had to face the 20% taxation. Your Excellencies, the preamble of ARTA
in its imposition of taxation, did it specifically single out the respondent? So how, I'm failing to understand how this was a violation of the most favored nation principle.
Well, Your Excellency, Alducra and Romania are the two only nations in the world that produce agave. So since the moment that Alducra, the applicant already has the rules of the statutes going on in their own territory since 2015, it is the most favored nation. So to comply with it, it is necessary a contest of equity. So the respondent will be able to comply with it. So it wouldn't happen any disadvantage or advantage from each party. Since it is in the contest, there is a clear disadvantage on the whole implementation of the statute. The preamble of ARTA even recognizes that environmental measures shall be taken. Yes.
You're making your argument in regard to the non-intervention principle and the sovereignty principle. However, I do not seem to understand how come the applicant in this case is actually intervening by actually taking measures in order to comply with its international rules under other international agreements. So I don't seem to understand the relation of the non-intervention with the actions from the applicant.
Well, Your Excellency, since the applicant is imposing a taxation to the product that will be sold to the other nation, to the other countries, it is an intervention, a direct intervention. They are basically saying that if the respondent does not comply into what they are imposing, they will be taxed. So they are imposing a taxation. They are intervening. As the president said, Romania, together with Aducra, is the only country in the world that produces tapetum. And to end my pleadings, it is important to remind Your Excellencies that since the beginning, Aducra did not recourse to appropriate remedy once negotiations failed, thus violating customary international law and conventions it is bound to. With all that being said, me and my fellow co-agent would like to adjudicate and declare that Aducra did violate international law with respect to its trade measures for tapetum product. Therefore, if there are no, may I finish my sentence?
Yeah, just finish your sentence.
So therefore, if there are no more further questions, I will end my pleadings and may it please the court.
The agents for the applicant have the right to rebuttal. We'll be adding 40 extra seconds if you would like to use that. So you have 2 minutes and 40 seconds in total. Whenever you please.
May I proceed with the rebuttal?
You may begin.
Thank you. So the respondent's agent has stated that mitigation measures should be taken with the applicant's help. However, that is not the case. Even though it is encouraged that developed countries help developing ones to meet in matters of sustainable development, in spite of conducting an EIA, they have ignored all studies which show that wind farms are harmful to bats, as well as the information from Chiropteris crusaders monitoring. There is no reason as to why the EIA wasn't extensive enough to foresee this point, and no reason for why mitigation measures could not have been implemented from the get-go. Such measures don't have to involve expenses. They could be, for example, reducing the cut-in speeds of the wind turbines and being mindful to migration periods of the bats and reducing operation at these periods to avoid trauma. Rumbedi also claims to be taking measures to avoid climate change, but they seem to have forgotten its commitments under other agreements, and even that biological diversity is an important key when it comes to climate change as well. Also, we would like to remind that bats have been found dead in thousands of other wind farms all over the world. So this isn't an exceptional case. This isn't something that is happening for the first time. And it is clear the causal link between the wind farm construction and operation and the bat mortality. Also, the respondent argues that Aducra tried to impose its own environmental agenda. However, all Aducra did was act in accordance to the international agreements and conventions it is a party to, which Rumbedi also signed, but somehow disregards in a number of occasions. Your Excellencies, do you have any further questions? Thank you for your time. It was an honor.
The session is now adjourned. The judges will be moved to a separate location to deliberate and will be coming back shortly. Agents for the applicant and respondent, you may talk amongst yourselves, but remember that this has been transmitted live to YouTube. Olá, pessoal. Parabéns a todos pelas apresentações. Já deu para quebrar o gelo, agora começando a competição de manhã cedo. E aí, como foi a experiência agora?
Nervoso, muito nervoso.
Nervosa, mas boa.
Ok. Daqui a pouco eles voltam aqui para dar o feedback. E assim que possível a gente traz o resultado da rodada. Sabe, né, que o critério para ir para a rodada final é pelo número de vitórias, né? E se houver empate, tem os critérios de desempate lá que a gente calcula depois. O terceiro juiz, ele teve imprevisto, não pôde participar, por isso que ficaram apenas dois juízes agora. Mas dois juízes muito experientes em multicorte. Então, um aprendizado interessante. Pelo visto, a internet, todo mundo ficou funcionando tranquilamente, né? A parte de tecnologia não deu nenhum problema. Nós estamos considerando aqui para a próxima rodada talvez fazer a contagem de tempo como se fosse um vídeo na tela sendo mostrada. Talvez seja interessante,
Nossa, eu acho melhor, bem
né?
melhor.
Para aparecer como se fosse ao invés de, tipo, como se fosse uma pessoa adicional e apareceria somente
Uhum.
o tempo. Vamos ver se isso funciona, se o Zoom permite fazer isso sem
Até
ocupar a tela
mesmo,
inteira.
acreditar, até mesmo os dois talvez seria o ideal, né? O tempo e a placa.
Aham, o tempo tipo, um
Porque, às
cronômetro
vezes, no
regressivo.
fundo, a placa fica camuflada, tipo assim, ela some metade.
Uhum. Por isso eu tava tentando ficar com ela pelo menos uns 15, 20 segundos mostrando para dar tempo de perceber. Vamos ver se funciona. Vou testar o vídeo depois, quando terminar essa rodada, para ver se funciona bem. Porque às vezes quando você transmite vídeo no YouTube, ou no Zoom, ele ocupa a tela inteira, e você acaba perdendo a visualização dos juízes e tal, aí acaba complicando, mas vamos testar. Os juízes estão lá deliberando, assim que eles enviarem as notas, aparece notificação aqui, aí eu trago eles de volta para o feedback. A próxima rodada é 11 horas, então tem tempo tranquilamente aqui.
Mas mesmo se não der certo isso de projetar o cronômetro, funcionou bem a placa, você fica segurando um tempinho, deu para ler.
Beleza.
Então qualquer coisa tá tudo certo também.
Eu achei muito bom também. Eu acho que assim, a placa não pode sair, sabe? Talvez o tempo seria um plus, mas eu acho que a placa funcionou muito bem.
Beleza, a gente pode fazer os dois. Okay, everyone, we are back from the virtual judges room. And once again, we thank both of you judges for taking the time to participate in the competition. You're making this much better. And now I'll pass on to Sharmisha that will be able to give you guys some feedback while we take a look at the notes.
Hi, everyone. So I have some feedback that I think applies to all participants. So firstly, I would say that quite obvious, but know your basics very well. So there were times when I actually wanted you to, I actually tested you on whether you know the fundamentals of international law. So whether it is as easy as a question asking what is customary international law to, knowing what is the Vienna Convention on Law of Treaties, what is the ICJ statute, where do you derive every single source of international law that you cite. So these the answers to these questions you should know like the back of your hand. They should come very natural. You should not hesitate before answering them. The second is whenever a judge asks you a question, always try to relate it to your argument, no matter which argument. Even if I'm asking you uh, a question that will relate to an argument that your co-agent will make sure that you deliver whatever the argument is concisely and precisely. And that kind of like brings me to my third point, which is always cite law when you're answering anything. So whether even if I'm asking something on facts, make sure that you establish where the law or where the basis is derived from. Yeah, I think that's about it. Apart from you guys were pretty confident, you knew your facts quite well, but it's just that you should know the basis of your arguments and try to reference the opposition's arguments quite a bit. So if I've asked a question to the applicant, which, for example, the applicant did not answer, or you as a respondent thought you have the exact point to rebut, make sure you do that in your submission. Vice versa, when the applicant is doing their rebuttals. So reference the judge's point, because in my head or in the judge's head, it clicks that, okay, you know what, I had asked the question and they're actually answering it, even if I was not asked that question. Yeah, that's about it.
I would add something to my colleagues' just final words. When it comes for the applicant should always take into consideration what would be the arguments of the respondent, and maybe trying to say, for instance, if the respondent, for instance, argues X, this would be something that we would propose as a solution to the problem. For the respondent, it is easy because they just have to respond to the arguments, but the applicant has to take into consideration possibilities and saying these words, for instance, even if this court finds that, or even if this court believes that, or this case might suggest that, and then you can address the issue when it comes for applicant and respondent. But something I would suggest is that, for instance, when we are in an online competition, of course, you have to speak clearly and having or giving time and breathing while you were speaking. So it makes it easier, not only for the judges to think about what you're saying and maybe relate to the questions we have and to the points we are to make, but sometimes if you also give us too much space and too much breaks in your argument, it invites us more to ask your questions. And sometimes that is not something that you would anticipate, judges' questions. So you have to make sure like not to speak very fast or to give us too much space in order for us to ask questions. So that's something I would suggest both teams to take into consideration. And not only that, when you are making your argument and you have a decision, an international decision to corroborate, don't wait for the judge to ask you what case are you relating to, or what is the basis of your question. If it is a case, just say the case. When it comes to this scenario, the International Court of Justice has already decided, or the WTO panel has already decided. Anticipate us or our questions. Anticipate your argument for us, because then we make the clicks without, as my colleague was saying, we anticipate the clicks of your arguments, and then, okay, I was supposed to ask that, and then they are already said, so that's a good thing. So those are my hints, and I wish you the best of luck to your for your other rounds, and thank you for this pleasant morning start.
All right, perfect. Well, once again, thank you both for taking the time to be here. I'm pretty sure that the competitors appreciate it very much. And to all of you, a very good morning, and we'll see you soon. Goodbye.